Okay, so good morning, everybody. If we'd like to take our seats, we'll try and get underway. So just to get things started, or before we get to the meat of today's presentation, just a few quick intros. So me, I'm Grant Conroy. I've been at Genus just for coming up to a year now. I've been working in finance for about 20 years, so I'm currently new to Genus and building a client base. I should also probably self-declare here that Leslie's my mother-in-law, so if you don't see me taking copious notes today, that could be because she's in the audience. So the other Genus PMs, if the other Genus PMs could just maybe stand up or identify themselves. There's basically, says Leslie, there's Sue, who here, oh there she is, sorry. Mary Lou at the back, Margaret at the back, and there's Steph as well there. So feel free to have a chat, ask some questions. Basically, also, we should have another PM joining us within the next few weeks, so kind of watch his space. So for this morning, we're glad to present our panel of experts series. So this is 6 years old now, and we think it's kind of becoming more important. We feel that the way the world is moving, it's becoming a little bit sort of more like multidisciplinary or interdisciplinary future. So kind of an example of this, imagine you had to go to a hospital and you sit down, you see a sort of generalist doctor, you might see some nurses, then you see a specialist, and maybe see a specialist nurse. You might see them all back to back. And it's kind of useful because it's a one-stop shop, and it's not too dissimilar to what some of the large banks offer. But really, we think the better value add is if you all sit in a meeting room together. So instead of having to remember what one person said and then try and relay that to another person. So if you can all sit down in one spot at one time, so you have the generalist doctor, the nurse, specialist, yourself, or the client. And as you go through things, everyone understands what they need to know from each other. And we think that that's a more important sort of step going forwards or evolution. So, for example, if you were going to see your accountant and you wanted us to join you, we're more than welcome to ask us, and we'd be happy to come along and assist you in working with your other advisors. So it helps better serve you instead of you going to see the accountant and trying to relay what they said to us. It might just make more sense. So if you'd like any of us to join the meetings, feel free to ask. We're more than happy to. So on that note, today we have Eli Walker and Jackie McQueen from Aaron, Gordon, Dakin and Nordlinger to present on family law. So Eli studied at the University of Victoria. He was called to the bar in 2008, joining Aaron, Gordon, Dakin, Nordlinger in 2011. His focus is on complex situations involving property division and support issues. And he also regularly presents for the continuing legal education of BC. Jackie graduated from Osgoode Hall Law School at York University. She was called to the bar of Ontario, BC, and New Zealand, so no jokes about the amount of bars that Jackie's been called to. And she's appeared at all levels of court in both BC and Ontario. So we're very lucky to have them both here today presenting, and I'll hand it over to you guys.
Thank you, Grant, and thank you all for being here this morning on this beautiful Vancouver morning. We are going to give a very generalist overview of the situation under the new Family Law Act in terms of property only. We're not going to touch on support. We're not going to touch on any child issues. But we are going to talk about some things that hopefully will be of interest to you. I'll start with a very brief overview of the property regime under the new Family Law Act. We'll talk specifically about common law status, which is one of the most significant changes under the new Act in terms of its applicability of the property regime to unmarried spouses. Then we'll talk about gifting and registration of assets, which again, hopefully will be a question of some interest for you. I'll then turn the microphone over to Eli, who will talk about the use of estate planning trusts and the use of prenuptial agreements. So as we proceed, both Eli and I are happy to take questions from the floor. So just raise your hand or stand up and let us know if something comes up. Otherwise, we'll field your questions at the end of the session. So, unlike the old Family Relations Act, which was quite focused on use of property, under the new Family Law Act, there are two classes of property. Either it's family property or it's excluded property. Property, property that is family property will be, generally speaking, anything that is owned by either spouse, legal title, or anything in which either spouse has a beneficial interest at the date of separation. If it's not family property, it is excluded property. Excluded property will include property that was acquired by either party prior to the relationship. So the example here is a person owns an investment account prior to the relationship. They own a condominium or a home prior to the relationship. That will be excluded property, at least in terms of the value of that asset on the date of cohabitation or marriage. Gifts from third parties. Needs to be a gift from a third party. A gift as between spouses is treated somewhat differently, but if a third party, a parent, or sometimes a business associate gifts property, that will be excluded property. Inheritances we've already touched on. The key point to remember, though, is although those assets, when they come in, are excluded property, any growth in their value between the date they come into the relationship or the beginning of the relationship to the end of the relationship is not excluded property. So that growth is subject to sharing. People are sometimes confused by that. So you have a condominium at the outset of the relationship. You don't actually live there. You maintain it for investment purposes. At the end of the relationship, 15 years later, in Vancouver's real estate market, that condominium is now worth $1 million or $600,000 more than it was at the outset. Even though there's no family use, even though we'll say in this hypothetical there's no contribution by the non-owning spouse, that increase in value is still family property. The other thing to remember is excluded property, to be an exclusion at the date of separation, must exist at the date of separation. So the example here is one party has a bank account with $100,000 in it at the outset of the relationship. Over the course of a 10 or 15-year relationship, they spend that money. They use it on holidays, they buy a vehicle, the asset is dissipated. If the asset doesn't exist on the date of separation, they can't claim an exclusion. They can't say, well, I had $100,000 in a bank account, so I want a $100,000 credit on my house. It doesn't work that way. You can trace it through. So for example, if that $100,000, instead of being spent on European and Hawaiian vacations, was put into a house, then we may be able to preserve the exclusion. And we'll talk about the specifics of that a little later. The Family Law Act, the overriding goal was to create certainty and keep parties out of litigation. There is a very strong presumption that anything that is family property is subject to equal division. And debt is also, under the new act, subject to equal division. That's a new thing. You used to be able to argue that under the old act, but under the new act, it's actually part of the legislation. It is possible for there to be unequal sharing, but you must prove significant unfairness. The courts are still trying to figure out exactly what significant unfairness is, but you need to keep in mind that it would need to be something out of the ordinary. The courts are not interested in looking at a relationship and saying, this person contributed 55% of the effort, money, and labor, and this person contributed 45%. They're not going to be interested in that. To prove significant unfairness, there would have to be something that was notable to most people in terms of what occurred during the relationship. In very limited circumstances, it's possible that excluded property, that is property that was a gift or inheritance or that you had at the outset of the relationship, may also be subject to division, okay? This would occur where family assets are outside of the jurisdiction and cannot practically be divided. So that may be a case where one of the parties is a foreign national, there's property elsewhere, that real property, that the BC court doesn't have jurisdiction over. So the court may say, well, we know that there's family property somewhere else, let's say China, or let's say somewhere in South America that has value. We can't access that. So what we're going to do is, even though the property here in Vancouver is excluded, we're going to compensate the non-owning spouse with that excluded property for property that can't otherwise be reached. The other specific factor under the legislation for division of excluded property is the length of the relationship or direct contributions by the non-owning spouse. So an example here may be where one party ends up in a traditional role, in a caregiver role to children or to parents or to other people as an assist in the marriage, and those direct contributions to the family, or perhaps it's direct contributions to the property itself. Let's say there's an apartment building that's excluded property, but one of the spouses does all the property management or other things that would impact that particular asset and give rise to significant unfairness. So that's the Family Law Act overview. If you have any questions about that, you can certainly address them. I'm going to move on now to one of the biggest changes in the Act, which is common law status. So prior to the Family Law Act coming into force, unmarried and same-sex spouses had no entitlement under the old Act to share in property. Instead, what they had to do is make a claim based on unjust enrichment. So on the basis that there was a trust that had been created, typically a constructive trust, where we would argue that a person had contributed time, effort, and value to property that was owned by the other party, and that not granting the non-owning party an interest in that asset would create unjust enrichment. And there was no good reason for that enrichment. The Family Law Act departs from that, and it's part of the modernization of several different pieces of legislation, including the Wills, Estate, Succession Act. So now spouses is defined as two individuals who are married. That can be same-sex individuals or different sex individuals, or, and this is for the purpose of property division, two individuals who have lived in a marriage-like relationship for a continuous period of 2 years. We're not talking about spousal support at this time. There is a slightly different test for spousal support entitlement in the definition of spouse. You don't necessarily have to meet the 2-year threshold if you have a child, but what we're focused on is property division. So it's a bit of a head scratcher, because what is a marriage-like relationship? And the Act doesn't actually specify or give us a checklist of what that is. Instead, where spousal status is disputed, the court is going to look at a number of factors, and they're going to balance those factors to decide where in the spectrum this relationship falls. So, was there physical cohabitation? And that's not necessarily a deal breaker. It's possible for people to be in a marriage-like relationship but live in different cities because of work commitments. It's also possible for them to not live in the same house because they have health or other issues. But it is one of the things the court will look for. Whether the parties have children together, and or how children from prior relationships are considered by the parties. So sometimes you have a blended relationship where people come with children from prior relationships, and there is very much a feeling of we're all a family now, and both parental figures have responsibility and authority over children. And then you have, at the other end of the spectrum, you have people who may live together, but their children are their children, and so that's something the court will look at. Economic dependence or independence. Do the people have a shared bank account? Do they have shared investments? Do they have shared plans around retirement? Do they have shared plans around acquisition of property, maybe purchase of vacation property together, that type of thing? Plans for the future. Do the parties portray themselves as a couple in the community? Do they hold themselves out as a married couple? Do they hold themselves out as people who should be treated as a unit? And finally, care for the other party during a period of illness. So all of those things, the court will look at all of those factors and others, because there may be factors that are unique to the parties, and decide whether or not they're in a marriage-like relationship. 2 years is the threshold. If you don't meet that threshold, that's a bright line. So the takeaway on this is the nature of the relationship counts. What you actually do on the ground, how you live your life matters. And it's so important, if you are entering into a relationship, that you clarify and discuss expectations. Eli's going to talk about prenuptial and cohab agreements later. But if you can, it's remarkable how often people think they're on the same page, and they're actually not. And even if you write down a memorandum to one another with your general expectations, it gets the conversation started. And having those conversations, especially in second relationships, especially later in life, where you may have moral or other obligations to other people, really helps. But the main takeaway is, don't get caught in the consequences of unintended consequences of a relationship. So now I'm going to move on to the question of gifting and registration of assets. Now this is often, this is less often an issue as between spouses, but it sometimes is. It's often an issue with respect to intergenerational transfer of wealth. So again, intention is critical. Now at common law, there are a bunch of what we call presumptions. And I'm going to highlight them because when I move on to later slides, you'll see how messy things can be, and how we're still not at a point where I can stand here with any certainty and say, if you do A, this will result. If you do B, this will result. So at common law, and this is the law developed by judges over time, where there is a gift between strangers, that is where I transfer something to you, you don't give me anything in return, there's no consideration, the onus will be on the recipient of that gift to prove that I intended to give it to them, and it wasn't just a loan or a caretaking arrangement. So that's called a resulting trust. Then there's a presumption of advancement. So, and this is gendered at common law. When a husband transfers property to a wife, or when parents transfer property to children who are under the age of majority, the law presumes that a gift is intended, that that husband or that those parents intend to give the property to the child, and the onus would be on the parent or the husband to prove otherwise. So the important thing is these presumptions aren't rules of law. They're simply allocating the burden of who has to prove what happens next if there's a dispute. So the question, how does the law treat a gift or inheritance from a third party that is used to purchase family property or is gifted to the other spouse? So the court is grappling with this, and they're trying to decide how those presumptions interact with the new Family Law Act. Here's what we know so far from the decided cases. That when a husband gifts excluded property, so something he received from a third party, to his wife, the gifted property is placed in the wife's name alone. The husband will lose the exclusion. So this is an actual case from the Court of Appeal. Husband receives money from his employer to protect him from contingent liabilities. He, as a means of creditor protection, gives that money to his wife, who purchases a property. They then separate. That, although that gift from a third party would have been excluded property, because he transferred it to his wife's name alone, he no longer has the exclusion. Presumption of equal division applies. She's arguably entitled to half of it, and in that case, indeed, was entitled to half of it. Second scenario, a husband contributes excluded property into a property held jointly with the wife. So husband receives $100,000 from parents or grandparents, uses that money to buy a jointly held townhouse condominium home. The exclusion there is not lost. We don't know that at the Court of Appeal or Supreme Court level yet, but the bulk of the cases in the Supreme Court say that. Next scenario, when a wife contributes excluded property to an asset owned solely by the husband, so this is the reverse of the first scenario, she does not lose her claim to an exclusion, and the reason for that is this gendered presumption of advancement from husband to wife, but not wife to husband. Okay, so there's unfairness there. Then we have a common law spouse, so unmarried spouses, but spouses who have been together at least 2 years in a marriage-like relationship. One transfers excluded property to an asset registered in the name of the other spouse. We don't know what will happen because, as between common law spouses, we don't know what the presumption of advancement will do. Okay, that will often apply in second or third relationships, so that's something to think about, and we don't have an answer for that. And then let's take the same-sex partner scenario. Excluded property from one to the other, we assume a resulting trust will arise. And likely, in the case of the common law spouses, a resulting trust will arise. But we don't know, given their inclusion within the Act, whether that will necessarily happen.
When you use the term gifted, does that also include inherited?
Yes.
Okay,
Yeah. I'm using that broadly because an inheritance is a gift. It's just typically a gift that occurs after the death of the person who's doing the gifting. So, what are your takeaways here? If you are making a significant gift to a child or a grandchild who is in a spousal relationship or who you anticipate will be in a spousal relationship, which is most people, be very specific about whether the gift is intended solely for the child or grandchild or whether it's for the couple. And wherever possible, record this intention in writing. I can't tell you how many times we see this, where money comes in, typically to allow a young couple to purchase property, and we don't know if that money is coming in for just the child or for the couple. And invariably, the non-recipient spouse will argue it was for the couple, it was a wedding gift, it was support for the couple. Make your intentions clear and keep a copy of whatever the document is. I've seen situations where there's a card which includes a check for $100,000 for a down payment, and the card says, "Dear son and daughter-in-law, we hope that you're able to use this to purchase a home." Well, that's probably good evidence of a gift to both parties. So if you want to avoid that, you need to be specific and you need to, wherever possible, record that in writing. Now, it's not in the slides, but also what sometimes happens is parents or grandparents will loan funds and they'll do a promissory note. And in the case of a promissory note, probably the best advice I can give, and Eli can certainly weigh in on this, is needs to be in writing, and that's for reasons with other statutes in terms of making sure that promissory note is valid. Make sure both children sign it if it's meant to be a debt of both children. Make sure there's independent legal advice if at all possible, okay? And if at all possible means get independent legal advice for the other spouse. Okay, now, so this is the next scenario. If you are making a significant gift to your spouse from your excluded property, so this is an inheritance that has come in, this is an asset that you held before marriage, so that can be either an asset registered in their name alone or an asset registered jointly. You have a complex decision-making matrix here to look at because there are tax planning benefits, there are estate planning benefits, and there's creditor proofing, and any of those things may weigh into your analysis. So what you need to do is make sure you're getting good advice from your accountant, from your lawyer, from your estate planning team, so that you know, if I do make a gift to my spouse, if I give them $100,000 to purchase a down payment on a recreational property, that I may lose that exclusion, and instead of getting $100,000 out, if things go sideways, I'll get 50. Now, I'm not saying you shouldn't do that. It may be that you want to do that. It may be that that transaction is part of an overall plan as to how you're going to deal with your assets. It may also be part of what you decide to put at risk in the event there's a breakdown of the relationship. Hopefully that makes sense. But you need to consider those things. My other advice would be, if at all possible, keep it joint, because we're much more confident that excluded property that goes into joint property, the exclusion will be maintained. Registration matters, title matters, how it's recorded in the land titles office. Before acting in terms of registration, and this is linked to the prior point, get advice and carefully consider how something should be registered. And remember, it can be in the sole name of either spouse. It can be jointly, either with the right of survivorship, which means on your death, the other party takes the whole thing, or without a right of survivorship, which would mean that your share, your specified share, would go to your estate. And often when people have children from a prior relationship, they want to protect that. So make sure you're not just taking the advice of the notary to register something jointly or otherwise. Make sure you're actually thinking about the consequences that flow from registration. Next point, if your children or grandchildren have or will receive significant gifts or inheritances, and it's your hope that this wealth will be preserved for future generations, state your intentions clearly, in writing if possible, and encourage them to get legal advice. If you're hoping that the $1 million that you leave to your child is going to then go to their children, and you're concerned about marriage breakdown, you want to try to make sure you want to give them access to that money. You need to try to make sure that your intentions are clear, and how they register the property and how they treat the property is really thought through. And finally, and this is a point that we always make to people who come in before a relationship starts: communicate, communicate, communicate. Talk about your intentions. Talk about how you hope the world will look in 5 years if you had a crystal ball. Make those things clear. And people are often, and I don't want to take Eli's topic, but people are often reluctant to do cohabitation agreements or prenuptial agreements. But it actually makes sense, because you should talk about these things before you become committed and before unintended consequences take over. Okay, so I'm done. I'm going to pass it over to Eli.
Thanks, Jackie. Jackie and I work in the courtrooms, which are relics of the 1960s and 70s, and there are no clip-on, non-handheld mics there, so we both find it amazing that we could just speak without having to hold a mic or be near the mic, and you guys can hear us. That's great. That's really good. Before I start on my stuff, if you guys were listening to Jackie's very accurate summary of what's going on in gifting right now and the exclusions of property, and you were thinking to yourself that line from Oliver Twist, "The law is an ass," you're right. On this topic right now, it's nuts. And we hope that if we're back here in 5 years, we'll have some logical clarity and consistent clarity on those issues. But right now, it's a total dog's breakfast, and that's just where we are. So I'm here to talk about trusts and prenuptial agreements. And I'm going to try and be pretty succinct, especially on trusts. I get pretty excited about trusts, but they can be a little dry and they're not relevant to everybody. And so before I get too steamed up about the issue, I'm not here to give advice about whether or not you should have a trust as part of your estate and tax planning goals. What I am here to do is to try and give some clear-eyed advice about how the family law will see that trust structure if that is part of your tax or estate planning structure. And so trusts have their own inherent goods in a trust and estate planning context. And the point of this slide, before I move on, is that the two takeaways I want to give you on trusts, one is that you can't rely on a trust to protect assets in a divorce. Family law will look through a trust, and that's what I'm going to talk about first. Second, when we come to prenuptial agreements, on prenuptial agreements, they can be very effective in managing the consequences of a divorce, but their scope needs to be conservative in order to give them the best chance of being successful in achieving that goal. Okay? Those are the two takeaways I want to give you today. We'll talk about trusts first. So, trusts are useful tools for tax and estate planning purposes. What they do, in simple terms, is they allow you to take your asset and, number one, diffuse the tax consequences of that asset amongst a bunch of different people, typically your children. Second, they allow you to defer the tax consequences of that asset to the next generation, again, typically your children. Now, sprinkled in amongst there may also be other beneficiaries that still allow you to diffuse those tax consequences. Your spouse, your siblings, your parents, a charitable, non-profit organization, et cetera, et cetera. Okay? But that's the goals of a trust, and they do that quite effectively, and most importantly, they allow you to maintain some control over the future use and disposition of that asset, even though you've diffused and deferred the tax consequences of that asset. And so that's very valuable. And so in an estate and tax planning context, you may already have trusts, or you may at some point in your life get advice that you should get a trust. And you should make that decision based on those tax and estate planning goals, not on what I'm about to tell you about family law. Okay? Death and taxes are 100%. Family divorce is only a possibility. And so you make those choices based on your tax and estate planning goals. Okay? So the point today is just to give you some clarity about how family law, though, will look at that trust. And the reason for that is this. That diffusion and deferral of tax consequences that I talked about, it arises because the tax law views trusts in a very watertight compartment way. It sees the trust and the property the trust holds as a distinct entity from the people who put stuff into the trust and the people who are going to get the benefit of those assets, the beneficiaries later. Tax law is pretty clear on that. Family law blurs those boundaries quite a bit, okay? And I won't get into the specifics of what the legislation says because the language is complicated and confusing, and we're not clear how it's going to be interpreted yet so far, but there are two ways that it blurs those lines. One is the language is specifically designed to allow a family law judge hearing a divorce case to claw back assets that were disposed of to a trust by one of the spouses into divisible family property. And so even though the tax law will look at that trust and say, well, the spouse doesn't own those assets anymore, they're not paying tax on them, they're in the trust, they belong to, at some point, the beneficiaries of that trust, family law will allow us to claw back those assets out of the trust back into the divisible pool of property. And so that's one of the key incoherencies that we run into when we're advising clients who do have trusts as part of their tax and estate planning goals is quite correctly, when they first come in to meet with us, they state that they have this trust and their assets in this trust, and they're one of the trustees or they're the settlor or something like that, and they expect that trust is off the table in the negotiation of their divorce, and it's not. And so that's one of the key takeaways that I wanted to give you guys about that issue. Yes, question in the back.
Will that bust up the trust, or do they simply say this value within the trust goes back in and becomes divisible?
That's a very good question. Thank you for asking that. I was considering just skipping that point, but that's very perceptive, and so let me answer that. The question is, when I say that the family law allows the family law judge to claw those assets back into divisible property, does the family law judge in fact dissolve that trust and make those assets in a tax way become part of the spouse's property again before they divide them? Or is it a notional division where they take the value of those assets that are in the trust, they assume that they belong to the spouse again, and they divide the other divisible assets on the basis that that spouse owns that money that was in the trust? Let's call it $100. And so do they divide the spouse's assets by saying, okay, we're going to assume you have that $100 and we're going to give the other spouse $50 more to divide it 50-50? The answer is the latter. They're not going to interfere with the actual operation of a trust. They're going to assume that the spouse who disposed of the asset of the trust continues to hold that value and divide other assets accordingly. Thank you for that perceptive question. I appreciate that. Yes, another question.
Would the same apply if the trust was set up for a person with a disability who then was married and was in a divorce, would the spouse of the person with the disability whose family set up a trust for them be able to access that trust, or would that be exempt?
Boy, that's a very good hypothetical. So the question is, what about a trust set up for the benefit of, let's say, a disabled child by one spouse? Could the other spouse, and let's to make it plausible, let's say it's child of a first marriage who's disabled.
I was thinking more the spouse of the person with the disability. So my son with autism grows up, gets married, can they get a divorce, can the spouse access the family trust that's been set up for him?
That's also a good question. I'll know, not the one I thought it was. Okay, so the question is, if I set up a trust for my child who's suffering from a disability, and then that child then marries or enters a common law relationship, and they're together for some time, and during that period, my child is a beneficiary of this trust that I set up for them, and then they break up. Is my child exposed to pay compensation to their spouse because of that beneficial interest they own in that trust that I established for them for their disability, to manage their disability? The short answer is yes, and that is a really convenient segue to the next bullet point there, which is the second way that family law will blur the lines on a trust, okay, where tax law doesn't. All right, and that is, as Jackie pointed out, and I guess I should pause there. The answer is going to be yes, but it depends. It's not quite as negative as just a yes, so I'll come to that in a moment. But anyway, the second way they blur this line is that, as Jackie pointed out, when you separate, family property is defined as any beneficial interest in property that either spouse owns. And that is specifically defined to include a beneficial interest in a trust. And so where tax law says, okay, sure, you have a beneficial interest in a trust, but if you haven't received any physical distribution from it, you haven't received any cash, you haven't received any shares distributed from the company, you don't pay any tax on the bare existence of a beneficial interest in a trust, because it's only a chance to benefit from something at a future point in time, dependent on the performance of the trust and the discretion of the trustees. There's no value there. You couldn't walk outside on Howe Street and say, I'm selling this beneficial interest in my trust, who wants to pay $100 for it? Nobody would pay anything, right? It has no fair market value, okay? In family law, though, in order to ensure that they err on the side of making sure we don't have a scenario where a trust fund kid who's had access to bags of money for the duration of a marriage due to a wealthy trust can divorce and say, I don't own anything, so you don't get anything. The family law will define a beneficial interest in a trust as property that the trial judge will be called on to put some kind of dollar value on and divide it. Again, pursuant to the question in the back, on a notional basis. They're not going to actually divide the beneficial interest in trust in a tax way, but they are going to make the spouse who does have a beneficial interest in the trust potentially pay some compensation to the non-participating spouse to recognize that that beneficial interest exists. Now, we haven't had an answer in the case law yet as to how a trial judge values that beneficial interest. It is an extremely difficult question to answer. And I pity the trial judge that finally does have to answer that question, okay? And one of the factors, no doubt, that trial judge would be called on to consider in making that valuation choice would be, what is the intention of that trust, and typically what has it been used for, and what will it be used for in the future? And so in that particular fact pattern, although the answer is yes, you're going to get a charitable ear, I think, from a trial judge on that issue, okay?
Would it be wise to have a prenuptial agreement that addresses that, and would that stand up in court?
You guys need to stop answering such clever questions that preempt my next big topics. Yes. So we'll come to that. Yes. Question.
Clarify that. Is that then full value of the trust that that person has a beneficial interest in, or just the growth of it from when that relationship began, for example? And then, so it's worth $100,000 today. When it grows, whatever, down the road.
That's an excellent question. Yes. So this again is what you guys are twigging on is that, again, it's a bit nuts that the family law does this, okay? And it is out of an abundance of caution. I think you're not going to read Hansard and read somewhere, we're worried about trust fund kids having a reported decision in the Supreme Court of British Columbia that everyone says is nuts, where this rich kid who lives in West Van and has $1 million budget a year provided by this trust paid $0 to his ex-wife. Out of an abundance of caution for that worst case scenario, the law puts beneficiaries of trusts, like a child who is one beneficiary of 4, and a trust that grows in value $100,000 during the period of their relationship. Do they pay $50,000, half of the total growth, or do they pay $12,500, half of 25% of that growth? There's no answer to that yet, and there's no clear answer to that in the legislation. I think that we can hope that, again, pitying this poor trial judge who first has to decide this question, that there is going to be a sensitive choice made on that front, that it won't be so blind as to say it's the total value of the growth of the trust and ignores the existence of other competing beneficiaries. But there's no clear answer in the legislation on that yet. And so that question as well, the question was, hopefully everyone caught it, because there can be more than one beneficiary of a trust, and commonly is, if the growth in value of the trust is $100,000 during the relationship, what gets shared? Is it $50,000? Is it half of the total growth? Or do we total up how many beneficiaries there are and divide the total growth by the number of beneficiaries and then cut that in half and say, okay, you're one beneficiary, so it's of 4, it's a 25% share of the growth, 50% of that 25% gets shared. There's no clear answer on that, okay? But again, that's one of the issues that will have to be grappled with by a trial judge eventually. Okay? So those are the two ways that family law blurs that distinction between a trust and its participants, that if a trust is part of your planning, you need to be aware of, okay? Now, that was all pretty negative. Moving to this next slide, I already told you about death and taxes being certainties, so regardless of the bad stuff I'm saying about how family law treats trusts today, please make those decisions based on your tax and estate planning advice, but know that when you show up at our office in that unhappy event, it's like going to the dentist coming to your divorce lawyer, but anyway, that the trust may not be looked at the same way. Okay? Now, having said that, before I leave trust, there are scenarios where a trust will still have some effective result in a divorce case. And those are, well, there's a few, but 2 examples that I've put up here. One is an estate freeze later in life. And this is a bit of a long, wordy paragraph that I'm not going to bother reading out. You'll see that it has a number of ingredients. Older, second marriage, estate freeze, disposition to the trust is made before marriage, multiple beneficiaries, none of which are the spouse who disposed of the asset to the trust, et cetera, et cetera, et cetera. The reason I'm going on like that is because there's this dog's breakfast of legislation that has a bunch of different criteria when the court can claw back the asset into the divisible property. And so all those little criteria that I've come up with there are trying to avoid all of those triggers that trigger a clawback, okay? The basic idea, though, is this. If you're going to dispose of assets to a trust with the intention to alienate them out of divisible property, you need to not be a beneficiary of that resulting trust, and the control of that trust needs to be diffuse. It can't be just you as the trustee, and it can't be just you and your brother, who of course is going to do whatever you say. Well, most brothers, maybe some, not some, but most. It can't just be you and some other trustee who's at your beck and call. Okay? There has to be, and so the perfect example of this, although quite frankly not a useful example in estate planning context, but to give you a sense of it, if you make a disposition to a truly charitable trust with professional trustees who are appointed to manage it, and the beneficiary of the trust is an arm's length charitable organization, is the property going to get clawed back into divisible property? Of course not. Okay? But very few people wish to truly and irrevocably alienate their assets in that final way unless it's part of their will. And so although that's a sort of absurd example, it gives you a sense of the kind of control that you have to let go of if you do want to use a trust to alienate assets outside of divisible property. The second scenario where having a trust will still have some effective result in a divorce is in that scenario where you do it. It wouldn't help you in your example, but in an example from the gentleman at this table here where you have a child who's a beneficiary of a discretionary trust and there's some risk in the relationship. Potentially there's going to be a divorce and the child will be exposed to pay some compensation to their spouse based on that beneficial interest. We can mitigate that risk by either deleting that child from the trust, which the child has no control over that. It's not up to them whether they remain part of your trust or not. And so that's a choice that's unilaterally available to you or the trustees. or second, diffuse the potential valuation issue by making sure there are lots of beneficiaries. And this could be done if it's a discretionary trust, generally at any time, but preferably it would be done at the beginning. You would have a broad class of beneficiaries, which might mean your issue and your children's issue. So as your children have grandchildren, the class of beneficiaries is expanding and the exposure of your children's generation is diffused, okay? You could also include a charitable organization as one beneficiary of the trust in order to diffuse again the number of beneficiaries and potentially reduce the valuation issue if that comes to that, okay? Prenuptial agreements, which are a much simpler way to deal with trust interest. That's the segue here, is that trusts are not going to be effective, generally speaking, to protect family law assets in a divorce. And so prenuptial agreements can be. The basic rules on prenuptial agreements are set out on this slide. And the basic rules are they're contracts, just like any other contract. Like any other contract, they're subject to the same normal rules that could void a contract: fraud, duress, unconscionability, things like that. So that stuff is not all that interesting for us to talk about. The family law piece of prenuptial agreements that is interesting is that in addition to those rules, there's specific language in the legislation that allows a court to vary a prenuptial agreement for being significantly unfair. Now, as Jackie said, we don't have a lot of guidance on what significantly unfair means, but the practical advice I can give you is that if you're dealing with a prenuptial agreement in a divorce of a marriage of, say, longer than 5 to 10 years, you must expect that the aggrieved party is going to challenge the prenuptial agreement in their claims. Now, whether or not that comes to trial, of course, is another issue. Most cases don't go to trial, less than 10%. But you can always expect, after a marriage of more than 5 to 10 years, that somebody will advance a challenge to the prenuptial agreement. And so the question becomes, what is your negotiation footing? And if you're starting the negotiation of a divorce with a prenuptial agreement, if there are issues that warrant a prenuptial agreement, that's always going to be better. But you can't expect after a marriage of 5 to 10 years that the aggrieved party is simply going to roll over and accept it, because the legislation gives them this out on significantly unfair. So there's typically going to be a challenge after 5 or 10 years. The question is, how strong is the challenge? How strong is your prenuptial agreement to hold up to that challenge? Was there a question here? I'll pause there. Yeah.
So, I mean, in any planning, usually, you have a will, you revisit it every couple of years if there's a significant change. Is a prenuptial agreement something you can revisit and reaffirm every 5-ish, whatever years if, your business is growing, if your, relationship may be perfectly fine, but to go back and say, is this still what we intended? Is this still valid for both of us? Should something, in the future happen?
You certainly can. And it's not uncommon to see those kinds of provisions in prenuptial agreements that contemplate a review every 5 years or so. The challenge with practically carrying out those reviews is that, as you can imagine, because your exposure in a divorce now, under the new act, is the growth in value of assets over time, number one. Number two, the natural progression of most relationships is increasing financial interdependence over time and increasing emotional independence over time, not to mention children. At every subsequent review, your bargaining power is going to be less and less. And so practically speaking, do those reviews actually happen? Typically, no. Okay? So you will find those clauses in a lot of precedents for prenuptial agreements, and they can sometimes